And today, the Supreme Court has answered that question by a vote of 6-3.
The U.S. Supreme Court has just issued a major ruling.
Major Second Amendment case.
Major Supreme Court ruling.
The Supreme Court just changed everything. The United States Supreme Court just dropped a legal earthquake, and the shockwaves are already rattling gun control laws from coast to coast. In a landmark 9-0 unanimous decision, the justices have redrawn the boundaries of Second Amendment protections. And what just unfolded could fundamentally transform how America approaches lawful gun ownership. For years, anti-gun legislators thought they had the upper hand, crafting limitations and building legal fortresses around enforcement mechanisms. But that advantage may have just crumbled in an instant. This isn't conjecture, not political posturing. This is a genuine ruling with tangible implications, and it signals the start of a confrontation that may determine the destiny of firearms rights across all 50 states. If you own, carry, train, or stand for your constitutional freedoms, you need to know what's happening. Before the mainstream media buries the story, hit that like button, spread this to your network, and stay alert. This is the moment everything shifts. Chapter 1. Supreme Court Game Changer. The Supreme Court has taken up an urgent case challenging permit mandates for firearms throughout all 50 states. This action places the entire permit framework in jeopardy and indicates a potential coast-to-coast transformation. The fact this case received emergency consideration reveals just how critical and far-reaching this ruling could become. Gun owners nationwide might discover a radically different legal reality very soon. The court will examine whether states possess the authority to mandate permits merely to possess or carry firearms. Emergency designation means the decision timeline will be significantly accelerated compared to standard cases. No previous case has simultaneously challenged every state's licensing laws at this scale. Should the court rule expansively, permit mandates could disappear instantly across the nation if this decision lands as many anticipate. We may be witnessing the death of government permission requirements for Second Amendment freedoms, a transformation that will cascade through every state and reshape the entire conversation around gun ownership permanently. Chapter 2. Free states setting the standard. In 27 states, citizens already carry firearms without requiring permits, which means millions of Americans are already familiar with exercising gun rights freely, without bureaucratic obstacles. For people in those states, the court's decision may feel like validation rather than transformation. Their daily experience may stay consistent, but the divide between them and permit-requiring states will become more pronounced than ever before. This ruling will spotlight constitutional carry as a proven framework for potential nationwide implementation. Constitutional carry, states permit firearm possession and carry without licensing requirements. Citizens in these states encounter minimal government obstruction. These Americans already experience the liberty to exercise their constitutional protections without waiting periods or costly fees. A positive ruling will anchor their approach within constitutional authority rather than merely state-level legislation. For countless Americans living under constitutional carry frameworks, this decision won't simply maintain their liberty, it will reinforce it by eliminating any remaining legal ambiguity. It represents a potential watershed moment in how America perceives gun ownership on a federal level. Chapter 3. Permit. States facing uncertainty. For residents in the 23 states that still enforce permit mandates, the approaching weeks may trigger chaos and doubt. Regulations that previously appeared solid may crumble or face legal assault. State administrations may rush to adapt, and regular gun owners may discover themselves trapped in legal limbo. Permit frameworks currently impose costs ranging from $150 to $800 in numerous states. Applications frequently require weeks or even months just for approval. Licensing agencies possess broad authority to reject permits with minimal explanation. The distinction between lawful possession and criminal charges could hinge on which side of a state boundary you happen to be standing on. This legal uncertainty threatens to compromise the foundation of equal protection under the Constitution. Gun owners in permit-required states should prepare for major disruption, not only in statutes, but in everyday reality, as rules transform and fresh uncertainty emerges. Chapter 4. Why permits face constitutional attack. The legal challenge presented to the court questions permit requirements as a fundamental violation of constitutional principles. The logic is straightforward. When government demands authorization documents or payments before you can exercise a right, that right transforms from inherent to conditional. This principle applies equally to expression, worship, privacy, or firearms ownership. The case may compel courts to reconsider whether any constitutional protection can be subjected to administrative gatekeeping. Challengers argue that government cannot mandate approval to exercise constitutional freedoms. They assert the Second Amendment deserves treatment identical to First Amendment protections, like freedom of speech or religion. They contend that costs and administrative obstacles represent contemporary barriers to rights. They maintain permit frameworks, stem from public safety objectives, not from original constitutional language. If the court embraces this reasoning, we might witness a comprehensive transformation in constitutional jurisprudence, where any statute making rights dependent on government authorization becomes unconstitutional. The ruling could dismantle generations of gun regulations constructed around licensing regimes. Chapter 5. The historical reality of permit laws. During court proceedings, historical documentation emerged demonstrating that permit frameworks were absent from founding-era legislation. Americans during the early republic openly carried firearms without government intermediaries. Permit statutes only started appearing in the early 1900s, frequently in jurisdictions with documented histories of racial or anti-immigrant bias. That background challenges the ethical and constitutional foundation of permit mandates as they exist today. Historical documentation reveals 0 founding-era statutes demanding gun possession or carry authorization. Early American citizens bore arms as an inherent right without government clearance. Permit frameworks emerged exclusively in the 20th century. Numerous systems were initially crafted to disarm marginalized populations rather than enhance public safety. This historical reality frames permit statutes not as neutral oversight, but as discriminatory policies rebranded across time. By revealing that heritage, the constitutional challenge gains ethical momentum alongside legal force, which may influence the judgment decisively. Chapter 6. States engineering fresh obstacles. If permit systems collapse, numerous states are already engineering comprehensive rewrites disguised as compliance. Some may quietly restructure regulations to circumvent the decision, while others may substitute permits with alternative barriers like compulsory certifications or insurance obligations. This struggle won't simply concern legal standing, but maintaining power over who can practically obtain firearms throughout the country. Anti-gun jurisdictions are allegedly preparing contingency legislation ahead of the Supreme Court announcement. Proposals feature mandatory firearm safety credentials before ownership. Additional concepts involve mandating liability insurance policies, comparable to vehicle insurance. Certain bills may require background verification for every ammunition transaction, or state-administered training programs with restricted capacity. These substitute systems may dodge the term permit, but accomplish identical results by limiting access through financial burdens, bureaucratic slowdowns, and private gatekeepers. The war over gun freedoms will migrate from courtrooms to state houses, insurance companies, ammunition retailers, and training facilities as state governments explore new methods to restrict access. Chapter 7. Disguised gun control. In jurisdictions like New York, California, New Jersey, Massachusetts, and similar states, the backup strategies are reportedly extensive from a regulatory standpoint, but deeply troubling from a rights standpoint. The objective is maintaining gun control mechanisms even if legal permits are eliminated. The battleground is transitioning from permit documentation to certifications, training requirements, insurance mandates, and ammunition purchase restrictions, which could effectively restore control through alternative channels. Replacement systems may mandate compulsory firearm safety credentials. States may require state-sanctioned liability insurance before legal carry. Background screenings could be necessary before each ammunition acquisition, even when gun possession is lawful. States may regulate which instructors qualify for obligatory training programs, with constrained availability generating extended waiting lists. These actions may avoid the label permit, but the effect would be identical. Continued limitations on access, administrative control, and disparity in who can exercise gun ownership freedoms. Citizens must recognize that eliminating permits doesn't guarantee authentic liberty unless they stay watchful against these disguised schemes. Chapter 8. Rights reserved for the wealthy. Permit systems and prospective replacement measures disproportionately disadvantage vulnerable Americans, frequently surviving paycheck to paycheck. For them, firearm ownership can mean the difference between survival and tragedy rather than recreation. Steep fees, mandatory training costs, insurance requirements, and stringent background or ammunition purchase regulations exclude those with constrained resources. What develops is a framework where rights exist theoretically for everyone, but realistically remain inaccessible. Expensive permit costs and obligatory training expenses exclude lower-income households. Extended waiting durations and administrative delays leave individuals vulnerable during dangerous circumstances. Insurance-based mandates may result in zero coverage availability or unaffordable premiums for residents of particular states. State oversight of instructor authorization may enable ideological filtering or capricious rejections. The outcome may be constitutional rights become available only to the affluent, the politically connected, or those prepared to wait and overcome obstacles, while millions remain shut out from meaningful access. This structural inequality contradicts what constitutional protections are designed to guarantee. Chapter 9. What follows? The decision. If the court eliminates permit mandates, the consequences will be swift and significant throughout America. States embracing constitutional carry will establish precedent, while others may oppose or seek to redesign statutes. Behind closed doors, federal litigation may become essential to compel genuine compliance. The outcome will depend not solely on judges, but on advocates, lawmakers, and ordinary citizens staying vigilant. States where constitutional carry already exists may witness confirmed freedoms without interruption. Permit-requiring states may rush to implement workarounds rapidly before enforcement commences. Fresh legislation may seek to rebrand restrictions as safety credentials or insurance requirements. Civil liberties organizations and gun owners may need to initiate new litigation to contest disguised limitations. What unfolds during the upcoming weeks and months may shape gun freedoms for generations ahead. If pro-rights Americans stay quiet or passive, the danger of disguised restrictions stays genuine, but informed and coordinated action could prevent those changes or reverse them completely. Chapter 10. Your part in this historic moment. This isn't the time for passivity or assumptions. Even if the court appears ready to deliver victory, genuine freedom requires public watchfulness and active participation. Understand your state's existing firearm statutes, track proposed legislation, and communicate with elected officials. If you value protecting your freedoms, engage with gun rights and civil liberties groups and maintain pressure to guarantee any legal transformations remain equitable and constitutional. Your participation counts now more than ever. Investigate and record your state's current firearm regulations today. Join local and national gun rights associations for legal developments. Reach out to your state representatives to voice support for constitutional carry and resistance to disguised restrictions. Distribute accurate facts with relatives, friends, and your community to build awareness and comprehension. Your involvement and advocacy may shape the future of Second Amendment protections nationwide. Stay informed and engaged to help direct outcomes, rather than simply responding when changes arrive. A new chapter for the Second Amendment. The battle for liberty isn't slowing down. It's accelerating with every legal challenge and every citizen defending their rights. Landmark decisions like this demonstrate precisely why vigilance, knowledge, and solidarity matter now more than ever. Gun owners across the country must remain alert, informed, and prepared to protect constitutional freedoms. Your rights matter more than ever, and united, we can guarantee they stay protected